is my CAN number. And my lord, this is the list of the writ petitions pending in CAN number. My lord, I can provide your lordship the list also.
Quite understand we are already. CAN number similar point. To appear for
CAN 27.
CAN
27
of
of 2024. 2024. And 873, my lord, in connection with MAT 873. Right?
873 of
2023.
you're giving that.
Look at list of CAN numbers only and nothing else. If your lordship. No. The identical cans I can give, and if your lordship doesn't want, I am not going to give. These are all identical cans on the same point. My lord, yes, advocate on record is my lord. She is the advocate on. Lord, I have also similar prayers, my lord. In respect of CAN number 73, my lord, arising out of. No, there are also several CAN applications, my lord, on the similar issue, my lord. Lord, I will not trouble your lordship.
Because we did not appreciate this conduct of yours. 15 advocates were heard. You were not there in the court at that time.
I'm sorry.
At closure of their arguments, we invited Mr. Bhattacharya.
My lord, I deeply bow down, my lord. Only thing, my lord, I will not trouble your lordship, my lord.
When we have finished it, you are ready.
I will not trouble your lordship, my lord. Only thing, my lord. Lord, your lordship knows this matter may go, my lord, before the apex court, my lord. Whatever is the fate, my lord. Let the CAN applications be, my lord, taken on record, my lord, so that it can be taken note of. Lord, I have given the numbers, my lord.
Wait.
Lord, these are filed in 2025, my lord.
The dates. You know the date. We know that people are not serious. To show us what is the affirmation date.
Lord, I can, my lord, give the affirmation date of one of the CAN applications.
You cannot give one you can give because you people are not serious. Now, when everything is coming down to the end of the matter, you trying to create another wave of round of submissions. This is not permissible.
No, these are all filed on 9th of June 2022.
We gave you opportunity.
Lord, I bow down.
We will not be adding all as additional of party. We will allow you to intervene and make your submission.
Lord, these are all intervening applications, my lord. This much I'm praying before your lordship, my lord. I understand, my lord, the difficulty, my lord, this bench is facing.
Don't talk about our difficulty. There are enough patience, and we are giving you outright.
I bow down to your lordship, my lord.
So you don't have to sympathize with us.
No, my lord.
No,
it's my fault, my lord. It's my fault, my lord. Well, these are all, my lord, served upon the board, my lord. No, these are, my lord, all notice of the service, my lord.
He's the counselor.
I'm appearing, my lord.
Mr. Pratik Mukherjee.
Yes,
only one.
Yes. With me is Shoma Pal, my lord. CAN number 73 of 2025.
Not, Malat, sorry. Malat, I have only one can, Malat. I have only one can, Malat. Can 32. Only one can 32, Malat. Here the applicants are trade qualified trained candidates. Only one can, my lord. My lord, my lord.
Where is Mr. Dasgupta?
Yes.
ভারতবর্ষ দেখো ছোট ছোট জায়গায় আটকে
In your cases, Mr. Mukherjee,
Yes, my lord.
they have filed independent petition.
ভীষণ আলাদা জরুরি
Yes, my lord. No, no, read petition is pending, my lord.
Respect of all the applicants.
Yes,
You write it down. You write it down. That all the applicants have filed separate petition. Yes. Write it down. Within the advocates.
may I your lordship I'm sorry
Yes, write it down with the signature of the learned advocate on it. Where is Mr. Dasgupta?
so he has left
সুদীপ্ত তো সুদীপ্ত
ও 35 নম্বর কোর্টে মামলা
No, just my lord.
No, no, what had the
My lord, my advocate on record is signing.
এটা লিখে দিলে হয়
Not can 32 of 2024. My lord, here the applicants are state qualified trained candidates. 32 of 2024. 873 of 2023, my lord. Here the applicants are trained, state qualified trained candidates. Their candidature was not considered only because their result was published by the board at the belated stage when selection was completed. So, my lord, because if the fresh selection is made, my lord, our candidature is considered, we will come automatically with the chain of consideration because we are trained candidates. So many untrained candidates are given appointment. We are all trained candidates.
Out of my lord, the scope of the petition, my lord.
is your petition pending?
No, my lord, it's application for addition of party, my lord.
And now,
32 of 2024.
you are all trained.
My lord.
সবাই আছে
No, my lord.
So, shut down. How will you come in soon? You have not been participating. You have not participated.
We participated. Our result was declared belated stage. Our state result was published by the board on the belated stage when selection was completed.
না না 82 থেকে পাস করা কেন 82 থেকে
So, you have not participated.
My lord.
আমরা টেট কোয়ালিফাই টেট ক্যান্ডিডেট
Deeply applies, my lord.
my lordship but may I have your lordship need to mention my lord no I had mentioned this earlier lordship so please to hear this can 26 my lord lordships are also pleased to direct my lord point out a order passed by your lordship whether I'm covered by it or not I am covered my lord this is a can where my lord I had my lord Correct. That has to be incorporated in my can because that was not passed in my can. I've come with your lordship's order also. But I'm a trained candidate. My additional
Request that order.
yes.
Similar order.
Yes. Well, Lord, this is marked if your lordship will excuse me. Director copy that. Copy director.
No copies, not
Well, Lord, I've got copies. That's right. But I had preferred an earlier writ petition, not nothing to do with this process. I preferred an earlier writ petition. This court, honorable court, directed it to be considered, have been considered and declared that my higher qualification should be taken into account. But it kindly comes to page 6. I am covered with this. Malad can 26.
আমাদের রেপুটেশন এখনো পেন্ডিং
My 15 can application for addition of parties. Prepared a list, my lord, where my lord the petitioner trained candidates and TET qualified. Our merit is compromised because my lord those person who are not TET qualified, they are given appointment. Even my lord, they have not participated. Their name also not appearing in the merit list. They also are given appointment. Now, can you see?
122 টা লিখে দিই, দাও
তারা বলে দিচ্ছে
এইভাবে লিখেছে।
It type down when we were here.
on the last occasion. On the last occasion, and some of the can applicant filed writ petition
Can
for 21 of 2024. Another ballot subsequent parties 2020 of 2025.
then why you are giving other can numbers?
Well, my can application.
Your can number is what? Dipendu Chatterjee, which can?
All can application.
All can means which can?
But I mentioned my lot 421.
Kept a copy.
No.
চিরকুটটা দাও না, একটা চিরকুট দাও না।
Plus,
Yes.
this much of sincerity is wanted.
চিরকুটটা দাও না, একটা চিরকুট।
You have given at rate indiscriminately so many times. You also do not know. You have not seen also. What is the date of affirmation of
Well, 2024 ballot I filed my lot 7 to 8 can addition of party, and to
where
2025.
is your this that this can affirmed on such and such?
Well, I can place before your lordship within 5 minutes.
Oh, that is our responsibility. You will not say.
But within 5 minutes I shall supply before your lordship.
Yes, 5 minutes.
My lordship,
Then we will ask.
Yes.
may I be permitted?
The list of matters.
And
no
date of filing.
further we are going to hear.
No, date of
We hand
filing.
over only. What is your parent can?
Parent can my lord 3, that is also
Can 3.
can 3, that is allowed.
Can 3.
Is allowed.
No, that
Studies দেখাতে হবে না।
Yes.
Then why you are mentioning?
No. 4 21, 23 of 2024, that is not allowed.
Your can, which one you are appearing?
Well, 4 of 2024, 21 of 2024, 23 of 2024, 20 all can 24 of 2024
By 4 o'clock, we want the list
Yes.
along with the date of affirmation.
affirmation. Yes.
Then only we will note your
Yes.
presence. Yes.
Lord,
Yes, who else?
lordship, my can numbers, my lord, similar, my lord, I have filed 9 applications in connections with MAT 3858 over 358, my lord. Party, my petition is spent.
So you give the list along with the date of affirmation at 4 o'clock.
Lord, date of filing is there, my lord, I'll give.
You have given.
I'll write the date of filing. Within 1 minute, it will be written. I have the applications. Date of filing, ওটা দেখে বলে দাও। 4, 5, December, and the writ petitions are also pending. Just date of করে দিচ্ছি আমি। এটা দিয়ে দাও, date of filing টা দিয়ে দাও লিখে। আমার just করে দিচ্ছি আমি। ওটা আমি পেয়ে।
No, you hand over.
Well, I'll just date of filing, I'll just hand over. But একটু রাফ আছে। হ্যাঁ। বলেছি না।
You have not filed it.
Well, my writ petition is there. Pending. Same advocate on record. Writ petition is there.
Yes.
Lordship.
Yes, Mr.
Fightingটা লিখে আমি দিয়ে দিচ্ছি। My can numbers are 31 and 72. I am similarly situated to the clients of Mr. Shamibul Bari that I was Mr. Shamibul Bari to the clients of Mr. Shamibul Bari that I was also deprived of not getting a chance to give the examination since it was published at a belated stage.
That's it, I don't understand.
Lordship, I unconditionally apologize, but
No, I don't understand that what is your necessity in this application.
Lordship,
Necessity will arise only upon we hold it on one way or the other.
Lordship,
Your writ petitions are there.
my lord,
All your writ petitions.
my lord.
You have to give us the list. You have to give us the list stating that all writ petitions pending.
My lord.
These are the applications file number is this.
My lord.
At 4 o'clock today, otherwise we are.
To mention,
Malad, one thing, Malad, only one thing, just to point out your lordship. Malad,
Mr. Kobir, what is your CAN number?
Lordship, can number 31 and 72, my lord.
Mr. Siddiqui.
Yes.
Grateful, Lordship.
My lord, I have filed one PAN application, my lord, 105 of 2025. 105 of 2025. My lord, untrained candidate, state qualified. And after selection, he acquired the training qualification. And the applicant is in thalassemia
Petition
patient.
is pending.
No, my lord, I have no restriction. My lord, the service may be protected because he is a thalassemia patient. I have annexed the all treatment documents in my CAN application.
You are appointed.
Yes, my lord. And my lord, the applicant is also a thalassemia patient. My lord, his service may be protected. 105, 2025.
What is your name, sir?
Uh,
Your name.
Praveen Maji. Praveen Maji.
Yes.
my lord,
I'm ready.
Well, I have two applications adopting the submission of Mr. Kobir and
You
Mr.
have already got your chance last time. You handed over, finished. Yes.
but item number can 69 that relates with Milord relates with physically handicapped candidates. Additional party application
You are already appointed.
already appointed.
What is your name?
Duke Banerjee.
CAN number?
69 Milord of 2025.
9, right? In connection with 873.
yes.
Yes. Physically handicapped candidate.
You are appointed.
I am appointed.
You are physically handicapped.
Handicapped. The number of successful candidate is
Yes.
one point in this regard. One point I would like to mention that the number of successful candidate is lesser than the vacancy. Number of successful candidate is lesser than the vacancy.
You are appointed.
Appointed,
You are working.
working.
That is your case.
That is my case.
Malad, we must start. Malad, last location, Malad says that the can two applicant names and roll number ought to furnish in a tabular form, Malad.
So, same.
Yes. And Malad, second thing is that Malad already, Malad, I handed over this my can application, Malad, all my can
It has not been.
no, Malad, can 70's petition is pending before the single bench, Malad. So that's why I want to indicate. can 70. Can 70. In respect of can 70, the applicant's reputation is pending before the single bench.
Can 7 has been allowed or
No, not yet allowed. That's why, my lord, I want to indicate it. Can 70 is reputation number, that is WPA number 13871 of 2024.
so we can tag your submission with what Mr. Bhattacharya has said.
Yes, but the thing is that, my lord, now, my lord, accept can,
70.
yes, my lord.
No.
Yes, my lord, can 25.
Of 25.
The 421 applicants is there, my lord. Their reputation is pending before the single bench, my lord. The point, some of the point is there create a resonating structure. That's why, my lord, I file this application, my lord, and I indicate all my can to this tabular chart, my lord. And the last occasion I handed over it also. Except can 70, my lord, it might.
Except 7.
There is no such, other applicants have no such reputation pending.
May I just indicate what are
They are the fresh applicant, my lord. This is the tabular chart of all my applicants.
70 does not have the reputation pending.
70 have the reputation pending.
The others don't.
Others no.
But only one submission, since I'm sorry.
where is it can 70?
Yes, my lord, there is there. Oh, 70.
Where have you stated that?
No, not yet, my lord, because today's is, my lord, that's why, my lord, I can hand it over it, my lord, the reputation number, by giving the reputation number. Except can 70, others reputation is not pending. That's my.
Except 70
Other is the fresh applicant before this court, my lord.
Madam, may I just indicate?
just
Yes, I'm sorry.
That's my instruction. Can 70 reputation pending before the.
Hello. Hello. এটা ব্যস্ত আছেন কি রে?
WPA number 13871 of 2020.
বিএলও মনে ফোন করে বিএলও টু মনে ফোন করে কি প্রত্যেকটা বিএলও নাকি চাইটা আইডেন্টি কার্ড
Madam, one submission, my lord, subject to lordship's kind consideration.
হ্যালো
Madam, on the last occasion, madam, I requested that the roll numbers of the applicants in Can 3, which was moved by Mr. Bhattacharya, may be supplied to us. My lord, we also wrote, no, it's 2, 3.
And they-
Three, madam, we are talking about Can 3, Mr. Bhattacharya.
I am appearing on can 2. I am not.
But Can
Why
3,
you appeared along with Mr. Bhattacharya?
Yes, but can 3 is not.
Keep the list.
Can 3 is not my. Dipendu Chatterjee's matter, my lord.
That is not our concern.
Yes,
Can roll numbers.
yes, sir.
madam, we have,
I
madam,
have given. I have given.
না টুতে দিয়েছিস তো এই
6.
আরে ফিদ্দ
That
সেটা
was
টুতে
in Can.
2.
That was giving.
Yes,
Madam,
it's already given.
we are now madam, the
Already given.
submissions were made from in Can 3.
আইডেন্টি কার্ড ফাড়া আছে কিছু
Yes.
No, madam, only one thing. In Can 3, why it is so necessary, we have definite information and appointment letters that 3 of the applicants are working as primary teachers. But madam, we do not have the roll numbers. Madam, we need to point out to your lordship that how many.
They do not give it. We will record content.
Then my lord kindly record. Yes.
My lord, the thing is that, my lord,
Yes.
We don't want any further discussion, Mr. Sami. We want you to give the roll number of
yes,
those
I will inform Mr. Chatterjee's, my lord, because that can.
giving by phone.
Yes, I inform. And my lord, another thing is that the submission is that if a person got appointed in a subsequent selection process, that does not debar him to
That our
give the
submission
challenge
we
in the
will make.
earlier.
But that submission we will make, but that disclosure of
That's it.
but
Because he is entitled to get benefit from. I mean,
But you have not told us as to whether anybody has got appointment in the subsequent process or not.
that is not the subject matter in this.
Why did you submit that one?
Because my learned friend submits it.
He will submit many things. Turns on
but my lord, the roll only the roll numbers may be provided to us.
Before that, only Malad, your lordship, kindly record. Malad, just because Malad, all the cans are Malad, some of the cans are misleading. Because Malad, one can is mentioned just now before your lordship, can 32 and 72.
stating burden upon them. We will not be giving saying that this fact has been admitted by you. This is offhand submission of applications. We will not say.
Malad, they have passed state in 2022. How can he challenge Malad 16 recruitment process?
If you make a substantive argument in reply, finish. We covered those points. Yes, Mr. Dutta.
So, only that Mr. Chatterjee would be directed to.
Yes, you get hold of Chatterjee and
Very difficult.
get hold of Chatterjee.
Well, 30 or more applicants are working.
পারলে আমাদেরই বলে তোমরা কি নিয়ে
Chatterjee আসবে না?
Yes, Mr. Yes, Mr.
But I think that my first obligation is to once again demonstrate before this court that how the writ petitioners and those who support the writ petitioners, they have stretched this proceeding much beyond the scope of the writ petition.
Yes.
But so many submissions have been made, we are completely oblivious of the scope of the writ petition. But I have placed the writ petition in my opening submissions. I will not place it once again, but please note down the paragraphs and the points once more.
Yes.
But what are the 5 or 6 facets of the writ petition?
Like your contention of the applicants in various camps, they have dragged the scope,
Including the writ petitioner,
Yes, we have taken. They have gone beyond their pleadings and prayers in the
Yes. Now, the scope of the writ petition are, according to me, 4 or 5-fold scope. First is
Yes.
scam in TET 2014. This is very, very important. Scam in TET 2014 is the allegation. Your lordships would find this in paragraphs 12, 16, 17 and 18. Just note down here. I'll not waste your lordship's time in placing those.
16, 17, and
18. So the fundamental challenge is to a so-called scam in TET 2014, which according to them vitiates the TET 2014. The second is, which again is contrary to the first one, is that all TET 2014 candidates are entitled to the benefits of relaxation by MHRD. I don't know how these two can go together, be that as it may. The second is that all TET 2014 pass candidates should get the benefit of relaxation of qualification granted by or allowed by the MHRD.
the submission was otherwise.
Yes.
Said that on the date of the advertisement on 26 September, the extension period was already over prior to September.
That's what
he says,
yes.
that the persons who participated, correct us if we are wrong, persons who participated as TET qualified teachers, in respect of them, those who came within from March to September, this period was a gap. So they could not have availed the relaxation. So something that was
Yes.
But
Election periods elapsed from the month of April, and thereafter the advertisement on the month of September. So in the interregnum period, there is no such relaxation.
That is what he
Yes,
said.
yes.
That was it. So
I have an answer to that also.
now what is they have not argued that all TET has to
No, that is the subject matter of the writ petition. My submission is that whether they can stretch it beyond the pleadings or the subject matter of the writ petition.
Second point was
Yes.
state what you are saying.
The second point is laid out in the writ petition, in the pleadings.
Yes.
The second point is, which according to me is contrary to the first point, is that all TET 2014 candidates should be given the benefits of relaxation. Yes, that is what I intend to point out. That what is the case and what is the argument?
This contention in which paragraph do you find?
Because these are available from paragraphs 7, 8, 9, 11, 12, 20 and 21.
Please explain what did they say? All TETs are not. They are not saying that.
Yes, can you have a look, Miller?
Which paragraph tell us?
Miller, 7 onward, kindly have a look, Miller.
That sir, your submission all TET candidates.
Yes, yes. Please,
Then the benefit
yes.
of relaxation.
Please take Miller. Paragraph number 7, for instance.
Yes.
It starts at page 29 at the bottom.
Yes.
Your petitioner state that on 11/10/2015, TET 2014 examination held in West Bengal, where huge number of students appeared. It is needless to say, this sentence, it is needless to say that on the date of examination, the notification issued by the MHRD, Government of India, was in force, and all students who have passed or qualified in the TET 2014 should get the benefit of notification of 9/4/2015. This is the pleading. I'm showing only one paragraph. The rest of the paragraphs, Miller, which I have highlighted.
So this pleading is contrary to.
The submissions are completely dehorsed.
Pleading is contrary to the submission. That,
Of Mr. Yes.
gap period is not their case at all in the.
Right. I have an answer to the submission also.
Yes.
That I'll make.
Yes. Now, if this is, what is your answer to this? This is right or this is wrong? That they should get the benefit?
Yeah, no, there is no dispute on that. They have got the benefit. That also I'll demonstrate. But I've got twofold answer to that. The easier way to answer is that they have got the benefit.
They have
Got the benefit. But, my lord, the other way also, my lord, the qualification, the gap that they are saying, the gap was also, my lord, filled up by the circulars of MHRD, which has not been brought to your lordship's notice.
Mr. Lively or Mr.
No, no.
Hussain or Mr.
Mr. Bhattacharya is placed the 2017. Yes, yes.
Yes, where is that in your compilation, that blueprinted? You know the page of that?
101. He's in his compilation, page number 101.
আমি একটা দিয়ে দেবো
They
এবার দুটো নেই
Yes.
101 is 17 amendment.
Or we shall got it.
Yes.
Your argument. All right, Mr. Bhagavad, if we forget, we will take. Yes. Yes, Mr. Bhagavad.
there is an additional submission to that also. Assuming there was a gap.
So you will go to that first. So
acha.
their argument, their
Yes.
contention was that all TET should get, that
Right.
all TET did not get the benefit.
Right.
It's other statement of theirs.
Right.
But you say that all of them got the benefit.
And that is recorded also. I'll place all those.
Yes.
But this is where the second facet of the writ petition. Where the third facet is, which is very important, in respect of, my lord, the relief that is granted is that what was the writ petitioners praying or claiming?
That relief they did not take.
No. The writ petitioners were claiming parity with those who have got appointment.
Yes.
And alternatively, they say, I must be fair to the court also. Alternatively, they say that if I cannot get appointment, the appointments which have been given is bad.
So their case was that there are vacancies. We have been discriminated
Right.
to give us a
Right.
This was their case.
Right.
So that is strengthened by the fact, according to you, that you see the prayer, there is no prayer for setting.
Right. This your lordship would find word in paragraph 11 of the writ petition. Then there is a, my lord, an omnibus submission or, my lord, contention raised that since 2011 there has been corruption in all selection process.
That you have argued
Yes.
corruption, etc.
Yes. This, my lords, will find, my lord, in paragraphs 14 and 22.
14 and 22.
22. And, my lord, the last point is that, my lord, no merit list was published and there should be a direction to publish the merit list with reservation and all that. Now, this merit list is for what? This is again very important. Merit list, not of the recruitment. Merit list of TET 2014. Yes. Please take. No. Kindly see the pleadings first. Then, my lord, we can go to the prayers. Please take me at paragraph 18 at page 34 of the writ petition. Your petitioner states that the board has stated in different cases filed in the High Court that so-and-so candidates were selected, but no merit list of so-and-so candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, reservation category wise should be published. Candidates were informed through SMS and no merit list of candidates were published, and it proves the mischief in the recruitment process. If the process was free from corruption, then there ought to have been a transparent merit list of the 2014 qualified candidates. The process was not completed in so-and-so, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers by the board in spite of the specific case. Steps not taken. And
Yes.
And in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have taken suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 2014 qualified candidates were not issued to, certificates were not issued to them. And even today they are fighting for that. There is no delay in filing. The public interest.
But what is your answer to their repeated assertion that no panel was published?
Yes.
The answer to
Yes, yes. But on that,
these 5 points you have.
Yes. Yes.
You please answer to their
Their contentions one by one. Before I go to that, please have a look to the prayers once more. My lords have gone through it.
Prayer, there is no prayer for cancellation of the recruitment process of 2006.
But the matter ends over there with respect. The standards charter does not apply. My learned friend Mr. Bhattacharya has found out standard charter. Standard chartered was a case which went before a special tribunal in a suit constituted under a special law. Yes, that judgment is on a point that if one issue is before the court, not before any forum, a connected issue can be argued or can be decided. But so far as writ jurisdiction is concerned, there are umpteen number.
The answer when you
Yes.
Now you please.
Yes.
How do you answer these queries?
Yes. Now, first, my lord, I take the point of relaxation. Where the rule is not under challenge. I mean the recruitment rules. Please have a look to Miller Rule 6, Sub Rule 3 of the 2016 rules.
2 years time for completion of training.
Now, this completion of training has happened within 2 years. No dispute on that. Number one, in my very respectful submission, if Rule 6.3 has been complied with, the issue of relaxation or the gap, as they are trying to point out, does not remain, my lord, an arguable issue or an issue to be decided in this proceeding.
So if this Rule 6.3 has been complied with, then also the persons cannot say that you have not conducted the inspection as per the procedure.
No. Please come back to Rule 60 once, Miller.
That is the argument which Mr. Pratik
Yes,
said, that NIO is judgment of our.
I'll come to that. That's why I say, Miller, I can answer this point through different modes. One of the mode is that Rule 60 itself takes care of the situation. We need not travel to MHRD. We need not address or dilate on, Millard, the gap, and then, Millard, whether they have undertaken this training.
Why do you say so?
Please take me Rule 6.3.
Yes, we have taken.
Now, Rule 6 is a rule for qualification. Then what should be the qualification? The training is one of those. Now, please take 3. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by NCTE and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered. And if the candidates with relaxed qualifications
We'll take it up any other day because we are out of time with the affidavit. That's why I came to say I don't want to disturb this big man.
Right. Please keep a watch on the list. We will keep on some other day that
We'll try and complete
the regular ways because my lord is not.
Yes, please. So, I'm grateful.
Well, I thought the 3 p.m. matter will be taken up.
No. Total stop. You have to finish today.
Permit me to stop when I am exhausted.
No. You are never exhausted. Running through all the courts for the government.
Yes, that's why I get exhausted. That is the reason I get exhausted.
Not recalled. That is what you say.
Itself takes care of the candidates who take the advantage of the relaxed qualification, that you get yourself qualified within 2 years. There is no dispute that whoever has got appointed with the relaxed
So
qualification.
MHRD extended, not extended, does not matter. Yes. Now let us come to play or the way you want to.
Yes. Now, my lord, assuming, my lord, Rule 6.3 does not take care. Does not take care of the situation or the arguments that they have made. I need to, my lord, answer that also. My lord, your lordships will kindly take, my lord.
Mr. Dotto, you are saying if 6.3 comply, then the court should not be looking into any other way.
Right.
Why you are saying? Qualification they might have had,
Yes.
but the procedural formalities have not been followed.
But
This classification, this panel, this publication. Then what is yours?
Those I'll take care. But I'll address your lordship on that. But please look into the relaxation aspect, because
Relaxation not we understood that this MHRD relaxation is not an issue after 6.3 has been complied.
yes.
Yes.
So I skip over, my lord, that MHRT.
Yes. But Mr. Dotto, have you seen that circular which Mr. Bandyopadhyay referred to us? Compilation page 101. He said that it has been extended.
There is a circular of 6th of September 2016, 2017. 6:30.
That is not September.
It's 6th September.
Yes.
But kindly read the amendment, the contention of the amendment.
Yes.
Yes.
That is why the judgment was cited by Mr. Or, but there was a trading after 18 months.
18 months.
That is confirmed because of the amendment and subsequent notification.
This was done in Sunny Abraham. That was the matter.
Yes.
Jaibir Singh. Jaibir Singh.
This was considered. And no, we didn't follow you. Now this reads this program shall be only for those in-service candidates and teachers.
Who is on which date? 31st March 2015.
Type of the
Yes.
That is why my submission was yeah.
without the training.
Without.
All right. Yes, Mr.
Appearing in the same compilation, page 63. That also has to cover this gap in the relaxation. Page 63.
Yes, Mr.
Milord,
Just one thing, indicate one.
please take Milord this circular of 6th of September. It's there on record, but just কি হলো?
You have given it in your compilation.
Yes, yes.
That's how. No.
আছে
You have given it in the.
বের করে দিন।
একবার দেখেন
85,
ওখান থেকে নিচে আচ্ছা ইয়েস মান কত
85.
পেজ 85 প্রবাবলি
Milord, page 85 of the compilation.
Page 85 or 84.
84 85 ওটা আমার কপিটা দেন ফাইনালটা
What you are saying is
Yes. Please take Milord the 4th paragraph. As per information available with this ministry, total number of in-service untrained candidate teachers in the state of West Bengal is 2,95,670, which includes this 32,000 and all. Then, however, till date, only 24,290 in-service untrained candidates have registered at NIOS portal so far. You may also check status anytime through so and so. Further, the clarification of various queries raised by the states have been uploaded at the NIOS portal at so and so. In addition to the above, MHRD has taken various steps for the conduct of this training smoothly. NCTE has been directed to give relaxation on the following points. Teachers who do not fulfill the minimum eligibility requirement for taking admission in DL Ed program, that is 50% in class 12, will have to join NIOS and reappear for class 12.
was the date now. This page says to allow all untrained appointed up to 10th August 2007.
Yes.
That tallies with the date which is
Yes, yes.
So up to 10th August 2017, materials on record proved that the relaxation was there. So question of reopening that issue does not happen.
But only 2 more paragraphs of this. Please have a look to the second page.
This
NCT is directed under section 29 that it shall provide relaxation related to the mandatory 2 years teaching experience in government recognized primary elementary schools in order to allow all untrained teachers appointed till 10th of August 2017, which is the date gazette notification of the amendment of RTE Act to apply for DL-E8 program conducted by NIOS. Then paragraph 6. Numeric 6. In view of the urgency and the time-bound nature of this matter, may I request your personal intervention to ensure registration of all untrained teachers at NIOS portal by 15 September 2017 and training by 31st of March 2019, and inform me steps taken by written correspondence. This is over.
এটা দেখো এটা অনলি ওয়েস্ট বেঙ্গলকে দিয়েছিল তারপর এই আনট্রেনকে সবাইকে ট্রেনিং করবে
So this was meant for West Bengal.
জাস্ট তলাই
But can you see who is it addressed to
দুশ্মনদারি
at the bottom? So and so Secretary School Education, Government of West Bengal. This with paragraph 4.
paragraph you just now showed us in Roman 2.
Yes, Milord.
It was 10th August 2017.
Yes.
But in clause 6, the dates do not tell. Untrained teachers by 15 September 2017.
Yes. This is where 6th of September 2017.
না 6th of September ওইখানে যেটা দিয়েছে সেটা হচ্ছে যারা ওই আগস্টের অব্দি যারা আনট্রেন্ড ছিল আর এই ডেটটা হচ্ছে এই ডেটের মধ্যে অনলাইনে পোর্টাল রেজিস্টারটা করে
This date of which your lordships find at paragraph number 6 is the date of registration for the purpose of completing the training by 31st of March 2019.
And your appointments were made prior to that.
Yes, but before August, I'll give you the date, Millard. I think it's April.
up to April 2017.
But April 2017, up to April 2017 were the appointments.
Explain to us
Yes, Millard.
that relaxation by the 9th April memo was till 31st of March 2016.
16.
Now advertisement came on 26 September 2016. So this gap from 1st April 2016 till 25th September 2016,
Yes.
how does this period stand condoned?
Yes.
রুলসটা আমাদের উইদিন টাইম
First is Millard, kindly look into the date of the rules.
Of yours is you did not go into that
Right.
because 6.3 complied.
Right. Next is Millard, this gap, whatever they call is a gap, has been subsequently Millard filled up. How? Now, this 6th September circular Millard I placed before my lords.
সময় তৈরি অ্যাডভার্টাইজমেন্ট ক্লজ 6
Kindly similar the date of the recruitment rules.
26 September 2016.
Right.
no no no
No, 2nd March 26.
That is prior to
Yes,
relaxation.
yes. So the 2nd March recruitment rule itself provides that get it done by 2 years from appointment. But under the rules,
Get it done.
yes. So Millard, under the rules, these people, Millard, have got the training done within 2 years.
Understand? That is your first.
Yes.
But this
But if my first argument,
is accept, no
the further things are not.
asking an answer.
Yes. Now, in respect of the further things, assuming Millard, your lordships required to go into that part, then the 6th September circular Millard I placed before my lords, which says that whoever has not got the training, and it is West Bengal specific, that is very important.
Whoever has not got the training, yes.
Whoever has not got the training will, the NIOS has been directed to undertake this exercise of imparting the training. You must get, the untrained people must get themselves registered within a particular time, and the tests are, or the training is to be completed within 31st of March 2019. But all my untrained candidates, so-called untrained candidates, were appointed by April 2017. September 2017, the MHRD takes note of all untrained candidates in the state of West Bengal, including the 2016 recruited candidates. The central government has the figures, 2,95,670 untrained candidates in West Bengal.
Yes.
Therefore, this relaxation was extended, in my very humble submission, by this 6 September circular irrespective of my rule. 6-3.
Date, my lord, 14th of September 2016, and the 14th of September 2016, page 63 of that my compilation. An order was passed by this court on directing the state to proceed with the appointment procedure. That direction was given on 15th of September. After that direction, advertisement, this recruitment notification was issued on 26th of September 2016.
Where is that portion proceed?
Yes, on page.
So what was the subject matter of that?
It was after 16, after 16.
ও ওকে আছে
তাছাড়া একটু দিতে আমার যে
কি দেখাচ্ছিস তুই?
এটা ওই কান্না
ও আচ্ছা
Yes.
Page 75. But in fact, this sentence.
No. Paragraph 4 answers that.
Yes. After 6 only, it's a statement. Amendment and subsequent notification. Then after 10th August 2017, were amended. That was completed.
Yes. Yes.
Now, my lord, this
This is over. Now what?
no, but only one thing. My lord, there is a judgment of the Supreme Court which also takes note of this.
জয়বীর সিং
No, I think it's there on record. It's there on record. Kindly take my lord 2023 SCC online SC 1584. Jaibir Singh.
Oh yes. Jaivir Singh is Justice Gawai's.
Yes.
That is NIOS.
Yes.
Class apart. Once training done, there is a separate. That is what is.
They appointed.
Yes.
But here, my lord, the 18 months training, taking note of my lord 6 September circular, my lord, has been approved. There is only one paragraph, para 56. But there is another judgment also, my lord, of Rita Haldar.
They have argued that.
Yes.
You have told us para 56, we shall repeat.
Wait.
Now,
But there is another Rita Mal. Rita Haldar Mal. But that is also below the compilation আছে না?
no, Mr. Bishop,
এই তাহলে অ্যাড করিস না যদি না থাকে
dustbin is there. Yes.
Therefore, my lord, this takes care of, my lord, the issue of that gap.
Question of panel, Mr.
Yes. Milord, before going to that, Milord, may I, Milord, take up, Milord, the point of Mr. Bhattacharya on the issue of implicit pleading. Standard Chartered Bank.
That you told us.
Yes. Now, please have a look to the judgment once. 2006, volume 6, Supreme Court cases, page 94. আমার কাছে খুঁজে পাচ্ছি না 600টা দে আমায় দি
Each paragraph yes.
Yes, just give me a moment, but I think আমি তো দাগ দিলাম গেল কোথায়
কালকে পড়ছিল তো
হ্যাঁ
You are relying upon Standard Chartered versus Andhra Pradesh.
Yes, but I'm distinguishing that.
Yes. Sorry.
But give me 1 minute, Milord. I've downloaded it, but I can't find it out right now. Achha. Yes.
হোয়াটসঅ্যাপ করলে বড় স্ক্রিনে করতে পারবে
হ্যাঁ ঠিক আছে এটা পড়া যাচ্ছে
Take our copy.
Yes. No, no, I've got it. Please have a look to the first paragraph. The first paragraph says these two appeals under section 10 of the Special Court Trial of Offences relating to transactions in Securities Act 1992 are against the judgment of the Special Court constituted under section 5 of the Act by which the Special Court dismissed Special Court suit number 11 and allowed miscellaneous petition number so and so which has been transferred to it. The Special Court, the claim made by the appellant, Standard Chartered Bank, herein therefore are negative in dismissed suit number so and so and the application made by the Canara Bank, etc. Not rest is not important. Therefore, my lord, under the Special Act, in a special court, a suit is dismissed, which ultimately goes before the Supreme Court. Now, kindly take para 71.
Yes.
Mr. Jetmalani rightly contended that. Rightly contended that when these admissions were placed on record formally, there was no objection by CMF to these admissions being taken on record, nor there was any challenge by CMF to the ruling given by the special court overruling framing of the aforesaid two issues. In the circumstances, he submits that it is not open to CMF to raise objection at this stage. Apart therefore, Mr. Jetmalani also relied on Order 12, Rule 1 of CPC to contend that it is open to a party at any time to give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case or the case of any other party. This was precisely what happened during the trial on so and so. Merely because such a situation arises, the rest of the case does not get affected and has to be tried in accordance with law. In Bhagwati Prasad versus so and so, while dealing with the argument that it would not be open to a party to sustain a claim on the ground which is entirely new or not pleaded, this court rejected the contention and held that it was the general doctrine which could not be applied irrespective of the facts of the case on hand, and observed thus. But in considering the application of this doctrine to the facts of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate considerations of substance. If a plea is not specifically made and yet it is covered by an issue by implication, and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle the party from relying upon it if it is satisfactorily proved by evidence. The general rule, the next part. The general rule, no doubt, is that the relief should be founded on pleadings made by the parties. But where the substantial matters relating to title of both parties to the suit are touched, though indirectly or even obscurely, in the issues and the evidence has been laid about them, then the argument that a particular matter was not expressly taken in the pleading would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know the matter in question, the matter in question was involved in the trial, and did they lead evidence about it? If it appears that the parties did not know that the matter was in issue at the trial, and one of them had no opportunity to lead evidence in respect of it, that undoubtedly would be different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and had no opportunity to lead evidence would introduce considerations of prejudice.
Yes.
Because this was exactly my submission, but in a different context. Here, the Supreme Court says that you cannot take a party by surprise. Or, in other words, one party cannot take the other party by surprise. With respect, kindly permit me to say this. Here, the court has taken us by surprise. What was adjudicated was neither pleaded, and I take upon myself the responsibility to say nor argued. Thank you, Churu. Thank you. What are these? Now, my lord, but I've already placed this judgment, my lord. Your lordship will find this, my lord, only one paragraph, my lord, from 2010 Supreme Court. My lord, this is not a new judgment, my lord. I have placed it on record. Please take, my lord, 2010, Volume 1, Supreme Court Cases 234. But this I have placed. But my lord, apropos, my lord, Standard Chartered, please have a relook to it. 2010, Volume 1, Supreme Court Cases 234. But I have an extra copy for your lordship, sir. I will. Yes, yes, yes.
What is the name of?
Yes, name is. Name to
Bharat Amratlal Kothari.
Bharat Amratlal Kothari.
Which paragraph?
The 29 to 33.
All right.
Just have a look to me at 33.
We shall look into it.
May I place it, my lord? Just may I place it, my lord? Your lordship would definitely look into it. I know that. Where under 226, where those principles would not apply. Where order, my lord, 226 is an order 19 proceeding. How would judgments like standard chartered would apply? Where, my lord, I must, in a writ court, we come with pleading and the evidences in the form of annexures. We,
Amratlal Kothari versus Dasu Khan, Samadhi Khan, Singhi and another.
yes,
You have referred.
yes.
You are saying para 33.
Para 33 is very important, but before that, my lord,
29 to 34.
my lord, para 33 is why important. For 29 onwards, my lord, I would like to place. Para 33 is important because in a 226 jurisdiction, you cannot leave it on the court to mold the relief. This is very, very important. Please take para 33. Often, yes, just may I place it, my lord? Though a high court, but this is in 226, has power to mold reliefs to meet the requirement of each case, that does not mean that the draftsman, speaking about the lawyer, that the draftsman of a writ petition should not apply his mind to the proper relief which should be asked for and throw the entire burden of it upon the court. The easiest way of getting out of, my lord, petitions which does not have the pleadings and the prayers by saying that the court has the power to mold the relief. So therefore, the court should mold the relief. And this is where, my lord, the Supreme Court goes a step forward or a step apart from the litigants and say, or my lord, hold that the lawyers should be careful to draft their petition. And this is a petition, my lord.
প্রেয়ার আর ওদের প্রিলিমস অনুযায়ী ঠিকই তো আছে, ওরা তো চাইছে না ক্যান্সেলেশন, ওরাও তো অ্যাপয়েন্টমেন্ট চাইছে, তাই জন্যই কনসাসলি ক্যান্সেলেশন চাই।
Well, the petitioners have made out a completely different case.
That was not their case.
Not their case.
He's answered the question of panel.
Yes, yes. I'll come to that. I'll come to that. I'll not run away. I cannot run away.
Selection committee.
Yes. Therefore, my lord, in this backdrop of pleadings, in the backdrop of the case made out, in the backdrop of everything that had happened before the court, my lord, whether, my lord, this kind of a judgment could have been delivered by, my lord, cancelling, my lord, the appointments.
Yes.
Now, my lord, on the point of rule issue, my lord, I would like to, my lord, place the judgment under appeal once more. Huh?
What will replace Mr. Dotto?
Kindly see, my lord, much of your lordship's time has been, my lord, consumed in this matter.
If you're sorry for that, then stop.
No, but I have been made to, my lord.
You have read the judgment, Mr. Dotto.
My lord, it is a judgment, my lord, with my with rest.
Argued about predisposition of the honor.
Yes, 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 yes.
We have taken note
Yes.
of.
No, but my lord,
We want your answer to the arguments.
sir, I'll answer the arguments, my lord. But, my lord, whether, my lord, please consider one thing, my lord, whether the points which have been raised, we are all entitled to raise whatever points under the sky.
These have not been dealt with.
No, what I respectfully submit is, my lord, in the backdrop of the judgment, my lord, whether, my lord, these points can be raised so as to support this judgment. Today, what is the writ petitioner and the others who are supporting the writ petitioner doing? They are supporting a judgment where your lordship will not find who argued what. where, my lord, there is no conclusions drawn by the honorable court, and abrupt, my lord, cancellation of, my lord, or, my lord,
Such circumstances.
yes, taking away employment. Kindly see, my lord, whether, my lord, at all your lordships will call this a judgment. Yes, kindly permit me to, my lord, place a, please take this judgment.
Yes.
My lord, first paragraph is, my lord, so and so have filed the writ petition and they did not get appointment. Please skip over, my lord, paragraph 2, where, my lord, rule 6 is quoted. Then paragraph 3, my lord, again refers to rule 3. My lord, my lord, kindly bear with me for some time. Kindly bear with me. But in the backdrop of whatever is argued, my lord, I need to, my lord, place it once again. My lord, through innovative arguments, my lord, blood cannot, kindly permit me to say this, blood cannot be supplied to this judgment.
Yes.
Paragraph 4, all these arguments I've made,
You
no, but my lord, there are no answers to it. Well, my argument was there is a.
that we have heard.
Could I say this? Kindly permit me to say this. My lord, placing paragraph 4 of this judgment, my lord, I had argued that the court has made a roving inquiry, but there is no answer to that. Your lordships, we read for your lordships. Paragraph 4, my lord,
Their argument was that what more inquiry is required?
Yes.
Because there had been large scale corruption. Charge sheet was produced to show that there had been crores of money transaction. Facts are so explicit that whether for the end that truth should prevail. That was their argument. 165 applied, rightly applied. Truth should prevail. Court cannot on basic what should I say, technical inference, court should not be blocked from delivering a judgment to that effect which may have the effect of cancellation of suit. That was in support of that Tripura High Court case was cited. Yes. So we have actually now they are ground of challenge. You have argued that scope of 165 you have argued. Yes. All of you have argued that in what circumstances this can be applied. You cannot be a prosecutor of your that has been argued. Yes. Their argument is see that it has not been the court has not acted as court has dependent on these materials which were brought on record by the board itself, and as such, you should go into this without whether there was any systemic defect in the processor.
Yes. Now,
But that your argument we have understood that your pleading you cannot mold the relief also. We want answers to this because Mr. Bhattacharya was stressing on the issue much that what has happened? Rule 8 not followed. No prior approval of the state government as required under Rule 7. Why? Why that is so?
First, Mr. Bhattacharya should support the judgment with the materials, whatever is there in the judgment. He is not an appellant over here. Now, please take paragraph 8. Well, what is being said that they have placed before the court, not a single judge, is in my very humble submission incorrect. Please have a look to Millard, paragraph 8, for example. From the pleadings of the petitioners, it is found that they wanted marks of the last empanel candidates of different categories, so and so, but no such particulars were supplied and produced by the board despite direction by the court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioner as well as from the court. Therefore, the system is bad. I assume for argument's sake that there is a suppression. 36,000 people will lose job. Kindly see the next paragraph. In respect of holding aptitude test, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. In this regard, the order passed by this court on so and so, not challenged, is required to be quoted. Pursuant to the order passed on so and so, evidence of the following named teachers who took interview of some of the candidates in 2016 recruitment process for the teachers of primary schools conducted by the board of different districts, namely so and so, were taken up. The real question was whether aptitude test of the candidates were taken or not. Who has raised this question? But someone has to raise this question. Right or wrong, Millard, the parties have to come before the court with this case, with this argument, with this pleading. But the entire system, Millard, of pleading and arguing, Millard, goes. Then Millard, there is a table, Millard, after that paragraph, Millard, below the table, Millard, at the internal page 80 of the judgment. No question asked by the appearing parties to the interviewers. The evidences record are kept on record. The parties, Millard, don't bring in witnesses. The parties do not examine, cross-examine the witnesses, and that will be a subject.
Not asked. No question asked by appearance.
Yes, why do I subject my...
No, that is just reported.
Please consider one thing, Millard. Do I subject myself to an irregular procedure and then try to pick holes?
You must have had that statement recorded in the order that I will not do this because this will go against me. Finished.
My lord, if the judge, my lord, acts as a prosecutor, and I have to. Please consider, my lord.
Basis of that you cannot say. This is a statement recorded in the order.
Yes.
You can say we were not allowed to speak, or my submission was whatever that.
Yes.
Before any court, if you want to say that, then when you are getting a statement recorded which severely affects you, or remedies are available to you.
My lord, I can get a statement recorded either through my witness by examining in chief, or my lord, by cross-examining my adversary's witness.
Right. That you did not do.
My lord, because, my lord, first of all, my lord, I don't say that evidence cannot be taken by the writ court. I don't say that. In an appropriate case, if the writ court feels it can. But question is, it is whose witness?
Court's witness. We take it is court's witness.
My lord, under which provision, my lord, may I, my lord, with humble.
Court. I am a lead court holding a. I
No,
cannot
no.
go well deputy.
My lord, then, my lord, the judge has to be examined as a witness. At least 20 judgments I'll give, my lord. Starting from 1873.
Doctor, this is like I will keep my mouth closed and I will take this point.
No, I would say, in the other way, the court is, my lord, shutting my.
That you have.
Yes.
You cannot.
Court is shutting me by saying that you have not asked anything, therefore everything is sacrosanct. How did the court?
Very good thought. For that a remedy is available. You cannot curse the judge. If suppose I commit a mistake, I make a statement here. You will say, my lord, you cannot record that because I have not said that.
Yes.
Yes. But I get annoyed. I say, Mr. Doctor, don't make further submission.
Right.
You will say, please record that statement.
Right.
There are plenty of ways, and you are a seasoned counsel, Mr. Doctor.
No, it's a different thing, my lord. Here, my lord, the example which my lords have been giving me is what is happening every day. Sometimes happens.
That I have to agree with all.
Yes.
You also know that you cannot win all cases. These are facts which are there.
But, my lord, this, my lord, with respect, kindly permit me to say this, my lord. This is, my lord, not the situation in our case. Our case is where your lordships ignores all the parties, calls the court officer and says, call X, Y, or Z. I'm going to examine him tomorrow. Where is this procedure laid down? Well, may I ask this question to myself? What your lordships are, my lord, observing today is where, my lord, the counsels argue before the court may accept it, court may not accept it, or, my lord, the court's observation, my lord, may not be to the liking of the counsel. Then the counsel says that, my lord, your lordship is observing this. I feel that this is not the correct procedure, or I feel that I am not being allowed.
We will say, Mr. Dotto submit such and such.
Right.
Record.
Right.
But suppose I don't record.
But where I find that I am a bystander and the judge is calling the witness, the judge is examining the witness, the judge has cross-examined the witness, and they then says that, okay, do you have any other questions to ask? But 165, I made my submissions. What does the court do? The court only asks clarificatory questions. Or if the court finds that the counsel who is either examining or cross-examining has missed an important point, there, my lord, the court intervenes, puts questions. That is the scope of 165. Where is the scope under 165 to call a witness?
Mr. Dotto.
Yes, now kindly see, my lord.
On his feelings now. You have argued this, you have taken note of.
My lord, rule 8, my lord, the rule 8 argument, but I'll no, my lord, may I say this, my lord? This is, yes. My lord, what has been argued, my lord, with respect, my lord, is only to divert the attention of the court from the judgment. If the judgment is a good judgment, support it through the judgment.
Yes.
Hmm? Kindly see my lord, paragraph 10. This statement, this finding at paragraph 10, who has made this allegation? Please take paragraph 14.
Yes.
But a judgment, my lord, without reference to any pleadings, any argument that the petitioners have argued this, the respondents have argued that. I think that the respondents' arguments are to be rejected because of ABCD reason. Therefore, this is my judgment. Or the petitioners' arguments are not to be accepted. Well, in the 30 places, the expression corruption is there without any material. Now, Rule 8, my lord, subject to correction, is nowhere to be found, my lord, in the judgment under appeal. Violation of Rule 8, I'll take up that point. It's not that. No. My lord, kindly see my para 16.
Yes. Yes.
Though the relevant Rule 7 of the recruitment rules mandates constitution of selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel. It was done by one outside agency. Where does the judge get that?
That is the evidence. Yes, Pasudan
This is not in connection with this matter at all. Yes.
Yes, Pasudan company was for TET.
My learned friends, clients should first make up their mind. Are they challenging TET 14 or are they challenging the 2016 selection?
Put that question to me. He said that it is a two-phase selection.
No, it's not that. No.
First is state, if you qualify, you apply for 2016. So, TET 14 and the subsequent processes, according to Mr. Bhattacharjee, could reflect from the records that the state proceeding and the subsequent was conducted by an outside agency, which identical bill was referred before the other division bills through which 26,000 parties were. That was his argument. So now today, if you say that no, ESPASU was only restricted to TET 2014, show us that. Because that you have not said in your affidavit in opposition. You have not said.
That's why, my lord, I wanted to, my lord, place. In fact, I placed the writ petition. If the writ petition is on X, I cannot be expected to reply on point Y. Yes.
Doctor, you forget about what Mr.
Very well.
To satisfy our point.
Very well. Now, my lord, let me, my lord, take, my lord, their best evidence.
There is no such statement, no such ground, no ESPASU, no outside agency, no prior approval, anything is not. To satisfy us that whether this ESPASU and company was pertaining to that issue or not.
My lord, with this caveat, that, my lord, this point cannot be raised, but I'll answer it. জাজমেন্টের ডেটটা কত রে? এই জাজমেন্টের ডেটটা কত? 22/5, তাই তো? 12th May. I believe, my lord, Mr. Bhattacharjee, my lord, has placed, my lord, the charge sheets
Yes.
of CBI. Please have a look to this.
No, before that, he placed that Esbasu and Gompa.
Yes, everything your lordship will get from the statute itself. They have done a full-fledged investigation. I'll show from there itself.
No, that is
You will show what, Mr. Let us understand.
What was the involvement of Esbasu as found in the investigation?
So that
Yes.
the easy your contention that Esbasu was the person found responsible for date 2014 as well as 2016.
No.
No. Where do we get?
Yes. Milord, your lordship will kindly take. Just take Milord page 70 of the bail application of Mr. Which Milord Mr. Bhattacharya has handed up. দেয়া আছে
Page 70.
Milord, page 7 0.
Mr. Dotto, are you not you to answer these queries? Do you want time or
Milord, I'll come back on the next day. But Milord,
we want your answer to these points which we pointed out to Mr. Sangha.
yes. Milord, I'll come back Milord on another day. Milord, Esbasu Milord, I can just show to your lordship 1 or 2 paragraphs.
That is page.
Milord, page 70.
ফোনও লাগেনি কোনো যোগাযোগ পাইনি ঠিক আছে তারপরে এগুলো লাগলা কয়টা হোম করেনি আর একটা পূর্ব মৈনাকপুরে ঠিক আছে পূর্ব মৈনাকপুরে আমি ফোন নম্বর দিছি ঠিক আছে
এইটাকে বের করে রাখ
পূর্ব মেদিনীপুরে তাকে নাকি ডাকেইনি বিএলও
যে এই কাগজটা লক্ষিতার নোটে আছে পেজ 90
ঠিক আছে আর
কালকে
একটা
দেখা
কথা ঠিক আছে আমাকে ওইটা কইতে কইলা যে প্রত্যেক সব
প্লিজ টেক মি লর্ড this second last paragraph of this page লক্ষিতা ওটা বের কর
তোকে ফোন করলে পাইনি স্বপন দাকে যেছিল স্বপন দা করে কিছু লাগবে না ঠিক আছে হ্যাঁ দেখি এতে আর যেটা কইলি এতে আমাকে ওরিকা কইলা যে প্রত্যেকটা সব লোককে ইনভেস্টমেন্ট যে
The charge sheet is tentative, trial is pending, what will happen? And if they get
no. Very well, then kindly take me this document which is not on record.
এটা জানি দে সব লোককে যে কোনো প্রকার
not on record. Why, Mr. Dotto, you got an opportunity to file an evidence for the read code.
Read code, I don't think was subject to correction. Esbasu Rai was not an issue. Not an issue over there.
এই এফিডেভিট যেটা বিকাশে রিলাই করছে তো অন্য মামলা
In this proceeding, Esbasu Rai was not at all an issue.
What document you are showing?
Milord, Milord, what was the role of Esbasu Rai in the recruitment process? Milord, I will place Milord a resolution of the board where Milord Esbasu Rai was.
That is November 2017.
No, Milord, it's on 4th of October 2016.
What is that?
Yes. Just have a look, Milord. একটা copy দেন না. But I can hand up, Milord, in a booklet made before on the next day. I'll serve copies on my land.
একটা কপি দেন একটা কপি দেন
এই আটা দে
এই ব্যাপারে একটা চিকলেট আমি বলেছি
No, you tell now what is written.
দিচ্ছে একটা
No, not required. Mr. Dotto, tell us now what you say.
So and so is requested to do the following jobs. What are the jobs? Arrangement for online applications for 1,25,000 TET qualified candidates and collection of fees thereof. This is the first job of. This is 6th of October.
4th of October.
I'm sorry, 4th of October 2016.
4th of October.
But this is a meeting of the board. Minutes of the meeting of the board.
We have a letter of 14 September 2016. That is page 130 of the compilation.
দেখ 130 তে কি আছে দেখ
Why? You have the compilation. Notes paper book itself.
Paper book.
From the documents which Mr. Bhattacharya
Yes.
you show us that why we shall not believe this.
যেটা দেখি যে বিল অ্যাপ্লিকেশন
Starts from page 123 of the paper.
পেপার বুক বলছে তো
Paper book which is annexed.
ওটার কোনো সত্য ওটার কিছু এই নেই ওটা জানি না ওটা তৈরি করা পিটিশনারদের তৈরি
মিলাদ
করা
Who has placed
No,
it?
no.
What has placed it?
No.
Then
It was handed over in the read code. It was handed over by the the petitioner, the learned lawyer of the petitioner, with a spiral binding.
No.
Not on record,
No,
not
no.
by the
That's
court.
no. Are you disputing this letter?
Absolutely.
Which one? Your signature
all-
you are disputing.
My lord,
Are absolutely won't do. You have
Yes,
to
my
tell
lord.
us why you are disputing it.
Yes, my lord.
Under your president's signature,
My lord, your lordship is referring.
as if you are seeing for the first time.
No.
We are hearing the matter. This is already there on you.
No.
This should have been
My
prepared.
lord, the page number, my lord, your lordship.
130, 131.
My lord, I'm just answering.
We are wanting an answer to the question in the argument that Basu was it was Basu interested for both these jobs?
Yes.
Mr. Doctor,
Yes,
you
ma'am.
will be making instruction. Please you will look into this document and make it page 131.
এটা আমাদের ইয়ে।
হুম,
এই তো।
131 দেখ
There is a bunch of documents.
yes
Out of those, page 120, 131 subject to be corrected.
yes ma'am.
Proposal for online application processing for internet.
এটা 130 আমাদের ডকুমেন্টস 130 আমাদের ডকুমেন্টস তো ভুলে
দাঁড়া
131 আমাদের আমাদের
page 130. Milord, I am trying to, Milord, place before your lordship what had happened prior to 130. What exercise was undertaken before issuing page 130.
Alright.
What was done, Milord, before the issuing page 130 is that the board had held a meeting in this regard on 4th of October 2016. This is what, Milord, I intend to, Milord, place before my lord. Oh, I'm sorry. After that, এটা দেখা না আগে. Please take this case. আরেকটা কপি দেন. Yes. Please take page 19 of it. This is part of the minutes. দেবো দাঁড়াও
প্রায়র ফার্ম গভর্নমেন্টের প্রায়র পারমিশন তো বলা আছে ওটা দেখাচ্ছেন কিনা পাইনি
Yes, what you are saying?
Milord, in the second, fourth paragraph, the members present in the meeting, not after that, it is also submitted. Where the paragraph starting with, before the paragraph number 1 at page 19, at the top of that page, handwritten para 19, Milord. where there is a para 1, middle of that page, just one line above that. It is also submitted that after publication of TET 14, result on 14/9/2016, the confidential processor had been requested to do the following jobs.
Who is this processor?
Confidential processor is S. Basurai.
Government process.
It is permissible under the rules also, I'll place.
I not get the copy to the
দিচ্ছি দিচ্ছি দাঁড়া আমার কাছে নেই, এই মুহূর্তে নেই না
Now, what would they do?
internal.
Compare Miller this page 19 with page 130 of the paper book. Now, what was their job? Their job number 1 was arrangement of online applications of for about 1,21,000, 25,000 TET qualified candidates and collection of fees thereof. So application arrangement, collection of fees. Then 2.
এটা তো এতে নিতে অনলাইন নিতে, এটা আলাদা সফটওয়্যার তৈরি করতে।
On receiving the online application, arrangements made for preparation of district-wise list for scrutiny verification and viva voce interview and aptitude test along with attendance sheet and dispatch the same to the board. Preparation of list only, not to give marks, take interview, etc. as have.
820 code.
No.
Meetings I am directed to say that the results of TET 2014 announced, now the following words.
Yes, the following words was subsequent thereto.
Yes.
Now, this has got nothing to do with Millard the core selection process. It is Millard an agency which has been engaged for the purpose of doing this administrative job, not to Millard scrutinize or Millard do the assessment.
এটা এক্সপার্ট নলেজ
of the candidates. I'll read this. What has been submitted before the court is as if everything was done by the S. Basurai in regard to the assessment of the candidates' marks, qualification, etc. That is not. I'll place it. This is the job that has been given. Then kindly see what will they do. On receiving, number 2, on receiving the online application arrangements made for preparation of district-wise list for scrutiny. Only the list will be prepared for scrutiny, verification and viva voce interview and aptitude test along with attendance sheet and dispatch the same to the board. But a list has to be prepared.
This clause C is post-TET 2014.
Yes.
Yes. So this says that arrangements will be made by whom? The confidential processor.
Yeah.
He will make arrangement for scrutiny, verification of testimonials and viva voce sheets for necessary entry. Who is he to go into the viva voce?
Where they will only prepare the sheet. Where that is the word sheet is important. They are not going to provide any marks. It's in a sense, it is called broadsheet. Dear lordships, officers, in the after the court hours, I find they have a sheet on which they note something, how many matters taken up, disposed.
Don't bring that.
No, I'm giving you an example.
That is too much.
So this broadsheet, this has to be prepared by them.
Yes.
So kindly see, Millard, along with attendance sheet and dispatch the same to the board. Arrangement to take up scrutiny, verification.
So your contention is viva voce and marks allotment was not by.
We'll all place everything before the court. We will place, if required, everything before the court. S. Basurai has not done anything. Only administrative job has been done.
Please show us, Mr. Dotto.
Yes.
Mr. Dotto, you have shown this. You please show us that approval which is required under Rule 7.
Yes. Now, so far as the rule is concerned, your lordship may kindly take Rule 4, Sub Rule 5E.